about it. And so we were deceived into believing many things that just aren't true. And so I think what you're going to, hopefully we're going to find through these classes and through these discussions is that, hey, wait a second here. These are things, this is where this stuff is all actually emanating from. And it is. And so what we need to do is we need to put attention onto these things. The questions and concerns that you bring up are very valid, but I think that, well, I know for a fact that a study of what we're talking about here will clarify all your answers. As a matter of fact, Bridget can speak to that herself, what we did earlier today. Bridget, why don't you talk about that for a second, what you've learned about this?
Well, you know, the thing is, like, I've been involved with common law for a super long time, and yeah, when, you know, I had to do all the birth certificate stuff and staple it to this and send it here and have it apostilled and then send it over here and have that apostilled and all this other stuff, you know, back when we were dealing with a lot of the Federal Reserve accounts, the TDA accounts that, you know, people have, but don't have access to because of the problem between the upper and lowercase name and the capital name, or the two birth times, or that a lot of that legal stuff doesn't work anymore. And that's one of the reasons Ken and I became friends, and I was willing to kind of listen to a lot of the work that he was putting out. And after conversation, having him on my radio show, and what I learned was that, you know, he was right. All this common law stuff and all these different types of, you know, work that people are starting to get into now no longer apply, because they won't let you into their courts at all. So you can't actually drag a common law jurisdiction into a court or a courthouse or file the stuff with the courthouse, because now everything's done electronically. And so you have to find, you know, ways to handle what they've turned you into again. So now we're like in the third process, which is copy, patents, and trademarks, is the third process they're running us through electronically to create, you know, money off of us, but it's all electronic. But nobody else or the courts will allow you to file those kinds of things electronically. So the fourth stage, and the fourth stage of this, once they get done with the copy, patents, and trademarks, maybe next year, they're going to be actually making money off of us through our DNA and our blood. So that'll be the fourth stage. But you're already doing anyhow.
They're already doing that anyhow, though. They're already doing that anyhow.
But they're gonna, they're gonna require at the bank that you give them 2 drops of blood to secure your bank account. So the bank will actually own your blood and your DNA. So that's the next step.
Well, they kind of already, kind of own it anyhow. But what's important here about these things is that we've got to focus our attention to what is the actual facts and truths of the matter. And the fact that, well, let me ask a question. When you guys signed these mortgage loans, what was your expectation of what this was? What was your expectation? What did you think you were getting when you signed this mortgage loan? Anybody? Somebody?
We were buying a house.
Yeah, and what was that? You said, what was a negotiable instrument? What's your understanding of a negotiable instrument? And what happened with that? What's your understanding of it?
Was that there was a contractual relationship, and once I paid, I got the house.
Yeah, but what happens with the documents that you sign? So in other words, it's originated by a bank or an originator. But what happens to all the documents that you sign? What happened? What was your understanding? What happens to them? They get sold to an investor, right?
Well, no, I didn't know that then.
Well, it either sits with the bank or it gets sold to an investor, but it gets sold as a whole package, you know, a whole complete package, meaning that when say it was originated by a loan originator, a broker. Okay, well, that broker is going to sell that to a bank or to an investor, and really the understanding of that is that it's sold as a complete unit, as a complete package, it's a complete whole loan, right? And that when it's sold, what happens? There's a bill of sale, right? There's endorsements, and and these of course are stamped and documented within the deed of trust that you signed, or the mortgage, depending what state you're in, and it's recorded with the county, right? And that's establishes a chain of title. So every time that thing sells, then what happens? It has to do the same thing again. It has to have a bill of sale and an endorsement attached to it, and that creates a chain of title, right? And that's what our general understanding of all this thing was. Is that correct?
Yep.
And also, what was the biggest understanding? The biggest understanding was that you had ownership, that
Yep.
you made that you achieved the American dream, which was to be able to get approved to buy a home and have and the opportunity for home ownership, right? And you
Yeah.
know, these things are what this is what our anticipation was, and this is everybody. I mean, the biggest biggest aspiration that Americans have is what? Buying a house, right? The American dream. And so and we believe these things, you know, but the only problem with this is that whole concept of ownership, that whole idea of a negotiable instrument that's signed, sealed, and delivered as a whole package, that's been dead for 20 years, but they never told us these things. So for 20 years, we've been going down this pathway with this misunderstanding that we have ownership, that we have that we have that we executed a negotiable instrument that if we pay this thing off, then we have, you know, after 30 years or 15 years, then it's ours, you know. But that's not what's happening here. We found that out when the economy crashed, didn't we? When all of a sudden this little sleepy giant, this little enigma called MERS, all of a sudden sprang to life, right? And all of a sudden MERS was just foreclosing on millions and millions of people, and there was nothing we could do to stop it, was there? Nothing. And so what happened here is we're defending these things, and for all these years we're defending these things, and then yeah, we win a case here or there, they throw us a bone, right? But overall, anything that we try to defend these contracts with is ignored by the court, and we're just seen as deadbeats, liars, and cheats. But the problem here is that first of all, there is no mortgage loan to real property. That whole thing is a deception. It was all, the whole economy as we knew it, the whole paradigm was thrown out between 1998 and 2001, and between like 2001 about 2004, the entire economic, financial, insurance, government, credit, telephone, manufacturing, everything, all of a sudden became automated by these patented processes. So all of a sudden, the human aspect that you had in these things, and we're humans, we make mistakes, right? And that's what happened. That's one of the big complaints when you tried to get a mortgage loan for years. You had to have, you know, it would take forever before you get approved for it, because you had to, some human had to, he has to prove this, and I haven't got his approval on that yet. We're still waiting for this person to approve that. So you had a whole human element in there, which was cumbersome and often failed and didn't always work out well. So the idea was, well, okay, let's automate the whole damn thing. Well, that was the biggest mistake that happened, because once you take the human element out of it, what happens? There's nobody everybody's following the technologies, and nobody's looking at the technologies, and everybody's taken for granted or being told that the technologies are infallible, right? And so what happens is now we have no human element to this, to people that we could talk to say, hey, wait a second here. There's these other aspects of this thing. But they don't see that. The government county employees don't see it. The court doesn't see that. The court employees don't see it. All they see is what? A deadbeat liar and a cheat who defaulted on their home, right? And what you have here is they turned common sense on its head. And I hate to say this, but we almost have to throw common sense out the window, because the common sense tells us that common sense tells us if you miss a payment and you're not paying on your mortgage, you should be foreclosed upon. I don't think anybody would argue against that. I don't think anybody would. But under these circumstances, if the question then becomes if it was, or the response becomes if it was 20 years ago, when there actually was a mortgage. What these things are is these are commercial lease agreements where they have sliced and diced our properties up into all different pieces: mineral rights, air rights, mobile air rights, water rights, mineral rights, and then created all these series of deeds and augmented deeds and complementary deeds, all these separate instruments, okay, that have been sold in all different various jurisdictions in this country and all over the world. Well, that's not a signed, sealed, and delivered negotiable instrument, is it? It's something a lot different than that, is it not? It's totally different. And see, we don't realize these things. We're trying to defend these things as if it is a mortgage loan or real property. And the real devious aspect about this is the fact that these damn attorneys know this. They are committing an illegal, as well as unlawful, as well as immoral act by filing these foreclosures. They know that these agreements are not negotiable instruments. They know that these are lease agreements. What they're trying to do is there's a hidden aspect to this thing. And that hidden aspect is that there's a whole estate tied to that all caps name of yours, which is invaluable. Okay. And what their whole purpose, this whole scheme that they devised, was to lure us into the false belief of a mortgage loan, real property, and ownership, and behind the scenes, what they were doing is they had taken our name by hidden contract, and they're impersonating us to pad the estate, to pad the annuities that attach to your name, the insurances that attach to your name, the other investments that you're not aware of that builds value to the estate. That's what they're after. So when people, I'm sure you've all heard the story, maybe it's happened to yourself, where there's people out there have never missed a payment. And then all of a sudden, the bank won't accept their payment. And they fight for the bank to accept the payment. And 3 months go by, and all of a sudden they've got a notice of default against them. And they did nothing wrong. This was a stimulated action against these people to stimulate a default so that they can, so they get thrown in, so it gets pulled out of the collective membership. And all these annuities become target marks now for these banks and these attorneys that want to go after these things. So what you have then is you have this false idea that there's a mortgage loan you're trying to defend against, and I don't know how you could possibly defend against something that's a falsity to begin with, and it doesn't exist. Number one. Number two, you're fighting a system that is totally corrupted because the court system is operating under admiralty law and maritime, and we don't have the standing there. And you're going to see that when I read this. We're going to go through a document here today. It's going to make this pretty damn clear to everybody. And so what we have to do is we have to turn our attention away from what's not working and realize that the only way that there can be justice is if there's a foundation of facts and truths. And frankly, there's none. There's nothing out there. Everything is a lie. Everything is the opposite of what you think it is. And then you sit there and say the fiction, well, the all caps name is a fiction, and it's theirs, and it's not ours, and it doesn't exist, and it's made up. You know, the stuff we're going to talk about is made up. It is made up. It's not real. But it's nonetheless not a fiction, though, either. Because if it was a fiction, it wouldn't affect my life. It wouldn't affect your life. We wouldn't be in the situation we're in now. Okay. And so what we have to do, and what I'm trying to do here, and hopefully I'm reaching people, I think I am, is to look at these things in the true light of day of what these things actually are. And that means that we have to basically take everything that we thought we knew or believed to be true. We got to throw it out the window. We got to start over again. And we've got to delve into areas that are unfamiliar to us and maybe don't make sense to us at first until you really start to really, dig into it a little bit, let your mind work things out and understand that, hey, I am the value of these things. I am the credit. I am the one that's funding these corporations. That's providing the capital for these corporations, and it's not by my physical efforts. It's by the energy of this what we call the soul or the form, that all capitalized name, which is not a dead entity. It's a non-human. It's a non-human factor of production. That's the energy value of us. And now if we were operating the system that we actually had lawful money, then it'd be a totally different matter. But we don't have that kind of system. Our system operates on valued credit. And where is that credit coming from? It's coming from us. Okay. Now I heard something that was, I got to convey this story here because this is exciting to me. This is a good thing. This is progress. There's a guy named Andrew Scaramucci. I don't know if anybody's ever heard of him or not, but I noticed he's been on the news a lot. He's been on CNN quite a bit. No matter what your feelings are about CNN or Fox, I don't care. That's not relevant here. The point is that he was interviewing on CNN. He's been on there several times, and he's coming out against Trump and all this and ways handling things. But after his interview, and he's a former Wall Street guy, by the way, that worked at Goldman Sachs back in the mid '90s, but was fired after a year. He's operated his own hedge fund and all these things. And you think at first, okay, this guy's a scumbag. He's a typical Wall Street insider, and blah, 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 and so on and so forth. But when the interview was wrapping up, he said, "Can I say one thing?" And I about fell off my stool when I heard this. And he said something to this effect. He said, "Listen," he goes, "we got a problem in this country. There's data out there. There's information out there that these companies and these banks are making money on. That information and that data is our information. It's our data. We should be getting paid for these things, not them." And he said that. So what I'm trying to do is I'm trying to get a platform together so that we, the people, can go after and collect on the value of our information that's being bought and sold that we have a right to get paid on. I about fell off my stool when I heard that. It's like, yes, somebody finally brought this into the public light. The only thing that he fell short of saying was that these are patents and trademarks. But all the elements were there. I mean, this guy I mean, basically what he did, my opinion, is he violated his whole Wall Street, his whole this whole trade secret, this wall of secrecy between Wall Street and the public by coming out and saying that, hey, these things, this information is not just data; it's valuable data. It's trading, it's controlling things, and it's earning money, and it's earning people lots and lots of money. But we have a right to that. So that was a good thing. That was a step in the right direction here, and I was very happy to hear that. And these are the things that we need to move towards. These are the things that we've got to get people to understand and get ourselves to understand that, hey, we do have value and we do matter. When you get to the, when you decide freedoms and liberties and the Constitution and all these things, what I've learned throughout this whole thing is that, I'm a United States citizen. I was born and raised in this country, and I have this inherent freedoms and liberties and so on and so forth. It's not true. It's true to a certain extent, but it fell off the wheel. It fell off the wagon in 1998 when this new economy was put in place, when all our freedoms and liberties were taken from us. In 2001, the OCC took all our freedoms and liberties from us when they said that we're going to protect the business of banking, and we're going to strip all the rights, causes of action, or the rights of action to sue banks. We're going to insulate the banks, protect the banks. And as a matter of fact, nobody can bring any actions against the banks. No government agency, no attorney general, nobody. The only one that can go after these banks and question these banks and their practices is us, the OCC. So what you have is you got the OCC who basically separated or forbid actually the rest of government from performing their oaths and duties to us by saying we preempt, we prohibit any consumer protection actions, any kind of consumer protection agencies, or any kind of involvement of the attorney general. So what they did is they separated the rest of government from performing their duties. So this squarely falls on the OCC, and I could see why they did that, because really speaking, and Bridget, you can attest to this. I believe a couple other people on here can attest to it too that are beginning to understand this stuff. Is that our name is quite valuable. There's no question about it. There's no debate there whatsoever. I won't call it the straw man. And I think it's a bad term to use because it's divisive, and it's nowadays it's divisive, and it's not really descriptive of what we're really dealing with here. But that straw man, if you want to call it that, does exist. The only thing about it is that he exists in innumerable pieces parts that we have hypothecated. So it's basically taking my person and slicing me up into a million different slices, and then selling them off, and then you think, okay, well, there's nothing left for me to cut up, right? Well, under patents and trademarks, there is, because it's all about art. It's all about a capricious whim. It's all about schemes and conjurings and processes that are put to government record or put to some kind of a system here that people are following, and people are under false pretense, mind you. You've got, if these things are lease agreements and they're not mortgage loan agreements, why the hell don't the court employees know this? The county employees know this. The state employees, the Secretary of State knows these things. Why don't they know these things? Because they were lied to as well. They're told to look at the technology and follow what's on the computer screen. And if anybody asks you a question, what do they tell you? That's a legal question. You got to go see an attorney. Well, wait a second here. You're the government. The attorneys are foreign agents. They have no loyalty to me, to you, to the Constitution, or to the people that it's supposed to protect. And so these are the things we're dealing with here. So when you're talking about, all these affidavits and the documents that Bridget was referring to, I did the same things. I put out an impeccable set of documents. I think they were impeccable. That took me about a year to prepare, and it was like 20 some documents. And I submitted these things to like 30 different agency heads. This was about 2-3 years ago. And I heard nothing back from not a single one of them, none of them. And I could tell you exactly what happened to them. They got the package, they took one look at it, and they tossed it right in the trash. Because one, anybody who tries to execute their equitable rights is nowadays seen as a sovereign citizen and a crazy nut and a fraudster, and is to be ignored. Number one, and number two is we're assuming that these people understand what we're talking about when we talk about these birth certificates, and we talk about all these things that we're doing as far as treaties and peace treaties and all these things. They don't know. They have no clue what's going on. So
and
the only way to
Yeah, one thing I was
Go ahead.
thinking about is like, okay, so when everything became electronic, which the attorneys worldwide are managing, by the way, and once the attorneys
Yes.
got control of this, right, there was no legal authority to override them. Okay, so I mean, we're not supposed to even have presidents under the so-called constitutional law. We're not even supposed to legally have, I think it's like the 13th Amendment, we're not even supposed to have attorneys as president. They cannot fulfill the duty under the Constitution. But we've had several of them that have gotten into office, which would be against the Constitution, because they're not supposed to be in control of things, and they're not supposed to hold offices and all of this other stuff. So once the attorneys now have, and this I've been putting it together as I've been going down my bunny hop down the road. But I realized
No, don't say rabbit trails.
I didn't. I said bunny hop. I'm doing my bunny hop. Anyway.
I know what. Yeah, you were cheating there.
Anyway, but what I realized was that there's no way that you could file any kind of common law documents anywhere, because nobody's going to take them, and they're not going to override what's happened to how attorneys now have morphed you into the electronic system. So they've made you digital. So there's nothing that you can file in paper
Yes.
that is ever going to help you in the digital system. So now what they're calling us,
That's
what
correct.
we are in the digital system, we're no longer a lost at sea vessel. We're no longer a little corporation. We're no longer a straw man. What we are now is, which, it took me a few days to kind of get my head wrapped around, is factors and production. So I was talking to a friend of mine who does math, and
Yep.
I was talking to him about factors. And one of the things he said, well, a factor could be 1 + 1. A factor could be like 1, 2, 3, 4, 5. A factor could be so many different things, but they could also,
Yes.
change us into numbers as well. So that's what they're doing. I mean, there's so many things that they're doing. And one of the things that happened was I paid cash my whole life, even for education and everything. I was raised with a father that was adamant about working hard and just paying cash. If you can't afford it, don't do it. So I didn't have really anything to use, to track down who I might be under their trademarks or patents, where they're making money off of me. So I actually found this place, and I used my CUSIP number. And if people don't know what your CUSIP number is, it's the number on the back of your Social Security card, because your Social Security card is a bond. So I found this site, and it's, wealth management companies and all this other stuff. And so I was going to see what they're, what's going on. And so I put my bond number in, my CUSIP number off my Social Security card, and I had 3,000 hits off the number off the back of my Social Security card. I had 3,000 mutual fund hits. And then the annuities.
And that tells you one. That tells you one thing.
The annuities were $15,000, and all of these started. They all go back, even the ones that have been cashed out already, to when everything became electronic. So, I mean, those are just like some avenues of the money creation that they're creating off of you. That's not the totality of everything. Yeah.
Tell them how you backed into trademarks, then, what we did today with the trademarks, what you found with these agreements, how you backed into that.
Well, I don't know what answer you want from me.
What we went through on the trademarks today, when we said, okay, when we were walking through those, remember I said go to test? And those links.
Yeah.
And we fought, she backed her way into this, to the CUSIP number, which is good though. That's a good way to do this. But one thing it showed her was, and it should show all of us, if you got that many hits out there, there's not any one account out there. There's thousands of accounts out there, number one. Number two, it gave her information that she may not have had prior to that, as far as different entities that were involved in these things, as far as money managers are concerned, and annuities and everything. So what we did was we took those names, and of course we went into the trademarks and patents and looked for them in there, and that's where all the agreements are for these things. So, this is where I start piecing this stuff together. And so everything goes back to patents and trademarks, everything. So once you get in patents and trademarks, that's where you start realizing, okay, something's going on here. This is where everything's emanating from. And so what I want to talk about now, if we can shift into this, is the agreements under patents and trademarks.
Yeah,
We look
can I
at
just-
contracts all the time.
Could I add
and-
just one thing
Go ahead.
before you go into that?
Yeah, go ahead.
I just want to tell them about what
Go ahead.
happened. So I've been working on documents and paperwork all weekend and trying to, find the information that I needed in order to, put these documents together. And I started to realize going through it that the attorneys actually have been trafficking people in their information. So the more data stealing that attorneys get and do, the more information that they have on individual people so that they can actually create money off of you, right? So the more people they get. So there are people in this world, because the attorneys worldwide control all of this. There are people in this world that have made so much money off all the people that they hold and how many pieces they've put them in since 2001 that they're buying $6 million yachts with a full crew, okay? And they're on the sea, right? Which is admiralty law. So they're living a lot on the sea. They're in control because they're captains of their ships, so they make their law. There is no court in the world that's going to be able to serve them paperwork, that's going to pull them in a court of law, that's going to make them responsible because they're not even on land anymore. And then, so there's this documentary that blew me so far out the door because that one attorney actually exposes this. But if you're not really paying attention to what Ken is trying to show us, you won't see it. But the guy in the document, the first guy, he has like a $600 million yacht, has like the biggest yacht in the ocean. All of him and all the attorneys that are doing this all have yachts. We're talking like $30 million yachts, up to $600 million yachts. They travel in clumps together and they meet people like in Dubai and Monaco are a couple of the places they really like to hang out together and party and show off their bling blings. Anyway, in this yacht documentary on Netflix called $1 Billion Yachts, the first guy that they have on said, well, I'm a retired attorney. But the way that he starts, stating the next part of the conversation, you realize he's been trafficking people in mutual funds, in this, in that, in this, and that, and creating revenue off of them. And now he's retired because he has a $600 million yacht and more money than he could ever need. And now he basically says that he's like a consultant and he does sales. And basically the verbiage that he uses is indication to factor and production. So he's now selling his lists of people to other attorneys for top dollar. And so one of the things that he says right in the documentary to the guy, he said, basically, if the public finds out how great this lifestyle, our lifestyle is with these yachts, they're going to bring back the guillotines. And that's when it totally hit me how much money that they are trafficking off of us and are reselling all of our information so other people can make tons of money in their company. So each company that they develop and build, they make all these patents, which are all pieces of us in them, and all the trademarks, also, those are all pieces of us. So all the money that those companies are making, and usually if you can find one company, the head, one thing I learned is that there's usually 50 more that they own. And what they do is that they take this money, once the interest comes through, once you don't make good on your loans and they can clear out all this cash that they've made, including the interest, what they do is they make another company to put that money into. So a lot of these companies don't actually do any kind of business out in the world.
They're just shells. They're just shells.
Yeah.
That's all they are. They're moving it. They're moving it. They call
So
it
you want to
workflow.
know? You want to know the people who are making money on you? You go watch that documentary, Billionaire Yachts, and those are the people who are stealing it all. They're stealing it all.
Yep.
Hey, can I interject something here? Because this is just, it's either sadly comical or comically sad. I just came across, as I'm working on my patent here, I came across something. Ken, you'll appreciate this. Ohio State, this is a news article. Ohio State can't trademark the word "the," patent office says.
Oh God.
They
Well,
tried
that
patent.
surprises me. You know, you know, the United States Patent and Trademarks Office has an assignment with an agreement with a German bank. You know what the trademark is for? Nothing.
No.
That's what the trademark is. Nothing. The word nothing. So when you, so yeah, when you say the, you know, I mean, I'm not surprised by that. You know, so when we talk about words now, we're talking about the meaning of words, right?
Mhm.
What are the meaning of words, and what are the meanings? Now, the is that's wild. That's absolutely insane. But that's what they're doing. They're using these words as the. Well, you know, Merrill Lynch owns all rights to the at symbol. That, you know, when you at Gmail, at whatever, they own the trademark for that. That at
They
symbol
own
is
the
trademark. Merrill Lynch
ampersand.
owns
Who
all rights
owns
to
the
that.
ampersand?
Yeah, Merrill Lynch does.
Oh my
Merrill Lynch
gosh.
does. Merrill Lynch does. So what we're you know, the meaning of words then becomes very important, but not in the sense that we're applying them to. We're applying them to contracts and everything but we're applying them to contracts that we're not seeing. You know, all the words, the meaning of words that we're talking about is under the term of art, okay, which is all originated on patents and trademarks. So what I want to do here today is I'm going to do the bedtime story, I guess you could say this is, and I'll post this afterwards. But I want you I'm going to read part of this agreement here because I want you to kind of absorb what the language is in here. We'll talk about the languages as we go through it and the meaning of words and how they're applying these words, and hopefully you're going to see how we're being abstracted and being converted to these different kinds of instruments and different kinds of entities or beings or articulations, okay, and how all this stuff is being pulled together and being organized underneath what deeds of trust and mortgages. And this agreement is an exemplary example of all of this. And so I kind of want to go into that. And what this is an agreement from 1999. So it was right after State Street, the ruling, which we've already talked about, but it was before the UCC, enacting of UCC revisions to Article 9, and it was 1 month before the International Trademark Treaty law took effect, which was basically says that anybody can take the use of your name and use it without informing you of it. So this was all very well planned out. Now, this is the conveying party in this is a vineyard. It's a vineyard called Sebastiana Vineyards, and it's in Stockton, California. And the receiving party here is the Equitable Life Assurance Society of the United States. And what this is this is a land lease agribusiness, okay? And now when I go through this, I'm gonna read about crops, and I'm gonna talk about crops a lot. Now what they're referring to in crops here, they're referring to the crops as far as real crops, as grapes or whatever, but they're also referring to the cooperative shares that are as the crop of investments, the crop of indexes out there, the crop of exchanges, the crop of stocks out there. So you got to look at these things in the abstract, and that's the hardest thing to do, is to try to put these things in abstract. And that's what we really need to start to understand, to really start having these things blow up in an aha moment. So that's why I kind of want to read this agreement and go through this thing and compare this thing to the deed of trust that you signed. Okay, this deed of trust here is a supplement to the one that you signed. Okay, so this is the ones that we did not see. So let me get into this here. Just kind of read this a little bit as we go, and we'll talk about it as we go through it. And this deed of trust made as of 4th day of May, 1998, by and among Sebastiana Vineyards, Inc., Delaware Corporation, and all other persons executing this deed of trust or any deed of trust. That's the key word, any deed of trust. Hereinafter called Trustor, First American Title Company, California Corporation, and the Equitable Life Assurance Society of the United States, the beneficiary, a New York corporation with a mailing address, blah, blah, blah. So it says, witness, for valuable consideration, receipt of which is hereby acknowledged. Trustor, that's you and me, irrevocably grants, transfers, and assigns to trustee in trust with power of sale all of the real property. Now, here's the thing. This is a vineyard that we're talking about here, but listen what the words are here. All of the real property in Sonoma and San Joaquin counties, California. So what they've claimed rights to, they claimed rights to the entire county of these two entire counties of Sonoma and San Joaquin. And it says, together with 0 shares of the capital stock of NA and the water rights represented thereby, all easements, and property or other or used in connection therewith as a means of access thereto, all tenements, I can never say this word, hereditaments, appurtenances thereto, including all water and water rights appertaining thereto, trustor's interest as a lesser. Remember, they converted us to leases. These are not mortgages. They converted these to commercial leases by slicing us up in all these pieces. Trustor's interest as a lessor in all leases affecting said real property, all buildings, structures, improvements, fixtures, attachments, and other articles. Now, when they talk about articles, they're talking about that non-factor all caps name as industrial properties, an article of manufacture. So all other articles now are hereafter erected on, affixed, or attached to. So what does that mean? That means that what they're saying there is that could be our name attached to a customer list. It's affixed to a label. Okay, you got to think that everything that these things are attached to. Two are located in, and all substitutions, replacements, additions, and accessions thereof and thereto, together with all appliances, equipment, and machinery now affixed or attached to or located on said real property, which are real property, and all replacements thereto, thereof and thereto, all rents, issues, profits, royalties, bonuses, income, and other benefits derived, the key word, derived from or produced by said real property, subject, however, to the assignment of rents and profits to the beneficiary herein, and all right, title, estate, interest, and other claim or demand, including without limitation all claims or demands to the proceeds of all insurances now or hereafter in effect with respect to said real property, which trustor now has or may hereafter acquire in said real property. Because you got to remember, these are investments, okay? We're the actual principal of these things, and we're lending them the rights to our property. Well, they're taking it from us, but we're the lender of property here. And so this is all. So we're the investor of all these things. We're the producer of all the energy and all the credit and everything. So I'd say with respect to said real property, which trustor now has or may hereafter acquire in said real property, and all awards made for the taking by condemnation or the power of eminent domain, or by any proceeding or a purchase in lieu thereof of the whole or any part of said real property. Trustor hereby agrees, acknowledges, and confirms that any and all vines, this is interesting, any and all vines, because remember, we're talking about a vineyard here, right? Any and all vines located on said real property are a part of the real estate comprising said real property, and except where removed due to disease or an act of God, will remain a part of the real estate throughout the term of the loans made by the beneficiary to trustor, which are secured by this deed of trust. It goes through and talks about, for valuable consideration received for share by acknowledged, trustor as debtor irrevocably grant, this is what you did to that hidden agreement, that hidden MERS agreement that you didn't know about, irrevocably grants and assigns to beneficiary as secured party. The beneficiary are the attorneys. That's the nominated agent. These are the attorneys. As secured party, a security interest in all of the following collateral, which is personal property. Now they're talking personal property, not real property, which is personal property, now owned or hereafter replaced by trustor. All personal property attached here to make part of hereof, which includes but is not limited to all irrigation and frost protection equipment, all winemaking equipment and crushing and pressing equipment, now owned or hereafter replaced. Equipment, office equipment, and furniture, now owned or hereafter replaced. All intellectual property, specifically including but not limited to all labels, trademarks, copyrights, and trade styles actually used in marketing of wine and grape products or any product. That's keyword, any product. Farm products, inventory, fixtures, crops grown to be grown, timber standing or to be cut, and minerals or the like, including oil and gas. And that's what all these properties are. They're leases, and all leases are oil and gas investments. Don't ask me why, but they are. Including without limitation all watering and irrigation apparatus, machinery, pumps, motors, generators, pipes, and sprinklers, and all proceeds from the sale or disposal of the collateral. This is a security agreement pursuant to the UCC, and beneficiary shall have all rights and remedies of a secured party with respect to said collateral under the Uniform Commercial Code, provided, however, that nothing in this long form deed of trust, assignment of rent, security agreement, and financing statement shall, now we're going to tell our remedy in here, shall prevent trustor from obtaining secured crop financing, which may include the perfection of a lien by the crop lender on the crops grown or to be grown for a period not to exceed the beginning of the next crop year. Now they're talking about actual crops, but they're also talking about the indexes, the crop of the basket of securities they're talking about here also. If trustor exercises its rights to place a single crop lien on the crops grown or to be grown on the subject property hereunder, such crop lien shall automatically be a first superior lien to the lien on such crop created hereby without the need for any consent or subordination from the beneficiary. Trustor, now here's where it gets real interesting. Trustor warns to the beneficiary that except for the security interest of ATEL, ATEL Financial Corporation, Toyota Motor Credit Corporation, and General Electric Capital Corporation as lessors of certain equipment, including in said collateral, the security interest of General Electric Capital Corporation and Cooperative Centrale, I'm going to try pronouncing this, Raffaelson Borens Lank Bank, BA, in certain general intangibles, including in said collateral and the security interest created hereby. The trustor owns, that's us, owns good title to said collateral, and as to said collateral hereafter acquired, trustor will own good title to said collateral, free and clear of all liens, security interests, encumbrances, and adverse claims of any kind whatsoever. Trustor agrees that all of said collateral which is erected on, fixed, or attached to, or located in or on said real property or any real property located anywhere shall be deemed to be, and my ink ran out there, so I missed a couple words there, equipment, including watering and irrigation apparatus, shall be removed from said property without the prior written consent of beneficiary, except that the trustor shall have the right, without such consent, to remove and dispose of free from the security interest hereof such fixtures and equipment as may from time to time become worn out, obsolete, provided that the trustor shall simultaneously, with or prior to such removal, replace such removed fixtures, and goes on and talks about other things that really aren't pertinent in this. This deed of trust is executed in duplicate, each of which is deemed to be an original. For the purpose, let's see, to protect the security into the deed of trust, trustor agrees to now. In these agreements that we're not familiar with, that they snuck by us and made us a party to, we have, and these are the trademark agreements, and understand this is recorded underneath the trademark. What they've done is by making us the grantor and the assigner, we have certain responsibilities, you and I, and these responsibilities have to do with making timely recordings to patents and trademarks, to keep the patents and trademarks current, and to copyrights as well. And we have these responsibilities as a assigner. Well, of course we don't know about these things, so we're not performing our duties, right? We don't know about any of these things. These things were never disclosed to us. We have an impersonator who is acting as the grantor, who has stolen our name and attaching our all capitalized name as an assigner to these agreements by what? A fixed label, right? And so we have all these duties as the assigner and grantor, but we're not fulfilling these duties because we don't know we have these duties. What a perfect one-sided system that these bastards, these criminal sons of bitches, have fixed for themselves. What they've done here is they've created a one-sided system to where they impersonate us. They set us up into, they set themselves into these big elaborate contracts, like Bridget was saying. You know, you've got 50 different companies coming off of these things, right? So they've created themselves a nice little money chain and power chain and wealth chain off these things that is built on our name. But at the same time, though, they're controlling the debt side of us, right? Because they've got their hand over us because they got powers of attorney over us. So when they want to cash in on us or they want to default us, what do? You know, that's exactly what they do. They default us because we're not fulfilling our duties and obligations to these contracts, because these are not mortgage loans. These are investment contracts that have options tied to them, securities. Okay, basket of securities. And so basically we are the money manager of our own special purpose vehicle, except guess what? Nobody ever told us that. Nobody told us. And then the OCC came in, and any kind of fiduciary duty that these brokers would have had to you prior to the OCC deregulation and preemption was dissipated. All those fiduciary duties were stripped from us. So you've got attorneys that are operating without any kind of oversight, violating our freedoms and liberties. They're occupying a position of Article 8 of the Constitution, which is the protection of patents and inventors. Well, I'm sorry to say, but you know, I'm the inventor of my life. I'm the one that has unalienable rights to exercise my freedoms and liberties to my free will decisions, of course, which I'm responsible for. They've totally taken control of that, and they've done it to these contracts. So to continue on, to protect the security and deed of trustor agrees to pay when due all indebtedness evidenced by said promissory notes, to keep said real property in good condition and repair, not to, okay, blah, 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 so on and so forth. Let me get to the parts where the parts that are more pertinent to what we're talking about, more let's see, to maintain, let's see, deliver property. Okay, to maintain, to provide, maintain, deliver to beneficiary proper insurance covering said real property and said collateral. Insure an agent against all risks of physical loss or damage, including war risks, like it's got to be a war and terror, foreign war and terror maybe, if available, with loss payable to beneficiary. That's interesting. In
Hey, so
such a
Ken, I just have one question. When was this
yeah.
when was this patent put through?
This was not a patent. This was a trademark agreement.
When was
this
the trademark agreement put through?
This was put through on September 13th of 1999.
Oh yeah. Well, I was thinking, oh my gosh.
It was a setup.
Well, they had the vineyard fires in that area, and I wonder if they set them purposely, and that's why nobody's gotten their insurance on their houses or their homesteads. And a lot of them are homeless on our streets here in Reno. Because they can't get anything from the state or government, and some people lost vineyards, so huge estates with lots of money, and people haven't been paid for them. I wonder if
what? And this says why. This says why.
It's exactly why.
Yes, exactly. I said to digress for a moment on what something you read and something you heard, or something I heard today, which is very interesting. This COVID thing. You've got all these tankers and all these boats and barges out there, and they're not allowing any of these people to depart these vessels. So you've got people that are mariners and merchant marines and shipping that have not been off vessels in 11 months. They have not touched their feet on land. So to me that's very interesting, because here you've got everything now is concentrated maritime. Nobody's touching the land anymore. And you pointed that out in the comments earlier when you talked about the billionaire yachts.
Yeah.
So when you start thinking these things, so you got to start thinking these abstracts, because this is the real world. This is the way the real world operates.
And this is the other thing, is like every tanker, every boat or whatever that there is, there's a captain, and the captain sets down the law for everything that's going to happen on that boat. It doesn't matter if that boat belongs to the US. It doesn't matter who it belongs to. It has its own law, its own set of laws, and it goes down the way that it's going down. So who are you going to get to peddle your, court crap? And do you really expect these people to show up? I mean, who are you going to pay to serve a guy on a $600 billion yacht to come to court because of, whatever? I mean, you're going to get your case thrown out because they're in Admiralty law. They're not touching land at all.
But they do have a place to go, and it's called the Admiralty, the Maritime Administration. I think it's department, and the Coast Guard, believe it or not, and the Department of Navy, because these are the agencies that deal specifically with vessels, specifically with shipping, specifically with departing vessels, and so on and so forth, and visas and all those things. So this all ties in with what we're talking about here.
Right. This is a thing that a friend of mine was telling me about. And I think that it plays into why they're having these yachts designed, big, because there is no, every time you have a new yacht, then they have to apply the codes for that particular size of vessel and include it into. So the bigger that they make these yachts are not included in any kind of under the Navy or any of these other people until somebody actually incorporates them in.
Right,
so they're
right.
Actually, these attorneys are outsmarting everybody. That's the key.
And when we fit into this, our role in this as a vessel, we are a shallow hold vessel is what we are. And also too, it's not kind of stupid, but it's funny, but it's not stupid or funny. Also surfboards too, believe it or not. I mean, this is the abstractions that we're referring to here, but, and I know that this is probably people are thinking, what the hell are you talking about? These are the things that you got. This is why I'm reading this agreement to you, so you can see all the abstractions that are flowing off of these things to get you to think that, hey, this is not that negotiable instrument, signed, sealed, and delivered that I thought I signed. This is something entirely different. And that's what I want you to get, that's what I'm trying to get you to see here. So to continue on, okay, here's the, I'm gonna read a part to you here. It's gonna describe exactly what's going on in court and exactly why you can't win in court. And it says this: to appear, this is Truster, to appear in and defend any action or proceeding purporting to affect the security of this deed of trust or the rights or powers of beneficiary or trustee, and to pay all costs and expenses, including cost of evidence of title and reasonable attorney's fees in a reasonable sum in any action, any such proceeding in which beneficiary or trustee may appear. To pay when due all taxes and assessments affecting said real property, including assessments on appurtenant, that's his curious word here, water stock, and all encumbrances, charges and liens with interest on said real property or any part thereof which appear to be prior or superior hereto, and all costs and fees, expenses. If trustor fails to make any payment, so if you fail to record and keep your trademarks, or keep the trademarks you're attached to, connected to current, you're basically failing an obligation and failing a duty and failing to make a payment. In this case, it would be a maintenance payment. So it says if trustor fails to make any payment or do any act in accordance with this deed of trust, then beneficiary or trustee, without notice to or demand upon trustor and without release in trustor from any obligation hereunder, shall have the right, but no duty, to make or do the same in such manner and to such extent as either may deem necessary to protect the security hereof, including specifically, without limiting their general powers, the right to enter upon and take possession of said real property. So that's why these sheriffs and these SWAT teams can come on your property and throw people out, because it says right here, to make additions, alterations, repairs, and improvements to said real property, which either of them may consider necessary or proper to keep said real property in good condition and repair. To appear and participate in any action or proceeding affecting or which may affect said real property, the security hereof, or the rights or powers of beneficiary or trustee hereunder. And keep in mind, these are attorneys we're talking about. To pay, purchase, contest, or compromise any encumbrance, claim, charge, lien, or debt which in the judgment of either of them may affect or appears to affect the security hereof, or may be prior or superior hereto, and in exercising such powers to pay necessary expenses, including employment, I love this, including employment of attorneys or other necessary or desirable consultants. Trustee shall immediately upon demand thereof by beneficiary pay to beneficiary all amounts expended by beneficiary in connection with the exercise by beneficiary of the foregoing rights and powers. This is the 1099s they're filing, 1099As they're filing against you, is it not? Let's see, what's that here? Okay, evidence title, okay. Expended by beneficiary and all costs, expenses incurred by the beneficiary in connection with the exercise by beneficiary of the foregoing rights and powers, including without limitation, costs of evidence of title, court costs, appraisals, surveys, and reasonable attorney's fees, together with interest from the date of expenditure at the rate per annum after default or maturity set forth in said promissory notes. If said promissory notes in this deed of trust or either of them are placed in the hands of an attorney for collection or foreclosure or other legal proceedings, trustor shall pay all reasonable attorney's fees for any services rendered by such attorney to beneficiary in connection therewith and all expenses incurred, including costs of suit and evidence of title, together with interest thereon from the date of expenditure at the rate, blah, 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 so on and so forth. The same kind of repeats itself. So basically, what's it telling you? It's telling you you don't even stand a chance in court. That's what it's telling you. You don't stand a chance. It's right here. It lays out the duties and everything right here. You don't have a chance in court. The courts have been corrupted, and it's clearly shown in here. It is mutually agreed that all awards of damages or compensation now or hereafter made in connection with any taking by eminent domain or condemnation for public use or injury to said real property or any part thereof are hereby assigned and shall be paid to beneficiary who may apply or release such awards or compensation received by beneficiary in the same manner and with the same effect as above, provided for disposition of proceeds of fire or other insurance. Trustor agrees to execute such further assignments or any such awards or compensation as beneficiary may require. Okay, what is that? Those are your duties. These are the assignments that they're talking about, that that we've been given the duty to maintain and to upkeep that we were never told about. So this gives them carte blanche control over us to sign our name to any damn trademark, any damn patent, any damn contract they want to without our even knowing about it. And this gives them the carte blanche right. Now, the thing about it is, all those profits, all those rights and interests and all those insurances, they're entitled, they're due to us. They're due to us because we're the ones that are the investor. But this is how they word these things in so that so now what you have here is there's no common law rights whatsoever. Because if you have common law rights, that's to say that you are the owner of all of these things. So you are the owner of your name, all the properties and assets of properties there too connected with common law rights that are inseparable. Except for liens permitted by law and which includes presumptions of voluntary agreement. So what am I reading to you here? I'm reading to you a presumption of voluntary agreement that we presumptively agree to these things, an agreement that we've never seen in our lifetime, right? And so this is where the action's at here. This is the stuff we've got to overturn. It's not anywhere else. It's right here in patents and trademarks. So they're saying, without affecting the liability of any person. Okay, I read that part already. At any time, or from time to time, without liability thereof, and without notice, upon written request of beneficiary and presentation of the deed of trust and said promissory notes for endorsement, and without affecting the personal liability of any person for payment of the indebtedness secured hereby, trustee may reconvey any part of said real property, consent to the making of any map or plat thereof, join in granting any easement thereon, or join in any extension agreement or any agreement subordinating the lien or charge hereof, upon written request of beneficiary stating that all sums secured hereby have been paid, and upon surrender of this deed of trust and said promissory notes to trustee for cancellation, and upon payment of trustee's fees, trustee shall reconvey without warranty the real property then held hereunder. The recitals and such reconveyance of any such matters of fact shall be conclusive proof of the truthfulness thereof. The grantee in such reconveyance may be described as, quote unquote, the person or persons legally entitled thereto, period, close quote. Trustor absolutely and irrevocably assigns and transfers to beneficiary all rents, issues, profits, royalties, bonuses, income, and other benefits derived from or produced by said real property. All of the foregoing are herein the rents and profits, quote unquote. Trustor hereby gives to and confers to beneficiary the right, power, and authority to collect said rents and profits. Trustor irrevocably appoints beneficiary its true and lawful attorney in fact at the option of beneficiary at any time and from time to time, either with or without taking possession of said real property, to demand, receive, and enforce payment, to give receipts, releases, and satisfactions, and to sue in the names of the trustor or beneficiary for all said rents and profits, and apply the same to the indebtedness secured hereby. Trustor shall nevertheless have the right to collect and retain said rents and profits as the same become due and payable, but only before the occurrence of a default under this deed of trust, and as long as no such default exists. The assignment of said rents and profits is intended to be a present and absolute assignment from trustor to beneficiary. Bullshit. And not merely the creation of a security interest. Beneficiary's right to collect said rents and profits is not contingent upon beneficiaries taking possession of said real property. Upon the occurrence of default under this deed of trust or any deed of trust, and as long as any such default shall remain uncured, beneficiary may, without notice, either in person, by agent, or by a receiver appointed by a court, and without regard to the value of said real property or any part hereof, in his own name, sue for or otherwise collect said rents and profits, including those past due and unpaid, and apply the same, less costs and expenses of operation and collection, including attorney's fees, upon any indebtedness secured hereby, and in such order as beneficiary may determine. The collection of said rents and profits, or the entering upon and taking possession of said real property, or the application thereof, as aforesaid, shall not cure or waive any default or notice of the default hereunder, or invalidate any act done in response to such default or pursuant to such notice of default. So what's that telling us? That's telling us that that nothing we do is going to matter.
Well, the other thing too is that how is one person going to go through a gazillion trademarks or patents to find out what's going on in your life, what's going on in your county, what's going on in your, I mean, there's just no way that you could actually ever find this stuff out.
No, that's
And so
right. That's correct.
you would buy a house there in that area, in that vineyard area. And then the next thing you know, it'd get foreclosed on, and then you would try to fight for it. And then ultimately the judge would just finalize it and kick it out. And it's
That's right.
all because of this trademark that the company came in and gave behind closed doors, because you had no privy to it, because you didn't ask for the trademark document. You
Right.
don't know it exists. So behind
Right.
closed, the judge rules, and they're favored because you don't know. And the other thing too is, like anything in court, admiralty, common law, law is based on presumption, but you don't
Yes.
know what the presumption is, and the presumption, it dates back longer than your mortgage on your house, so
Right.
they're always going to win.
Yep. Yes. Yes. It's a rigged system because, well, it's a rigged system because you don't, we talk about, people say, people say, I'm a child of God and I've got unalienable rights and so on and so forth. That's a blanket statement. You got to support that thing. We are natural persons. What is the definition of a natural person? I'll tell you what the real definition of a natural person is: just a body of living matter that's been separated and disconnected from its form, which is the all caps name. Okay. That form that they're using, what are they doing with it? They're molding it into whatever fashion, form, or shape that they want to. Are they not, through these patents and trademarks? And so we're disconnected from that. And of course, we've got intermediaries that are in between these things. So in order for us to have any kind of freedoms and liberties whatsoever, and to say that we do have freedoms and liberties, would be to say that we are an individual personality. Are we an individual personality? I mean, we say we are, but in the scheme of things, no, we're not, are we? We're being controlled and pulled every which way that they can pull us, and we have no remedy against these things in the system that is presently set up, and that is that we believe to be to give us the remedy that we seek. As a matter of fact, we've got attorneys who are supposed to protect and uphold the law. Or, pardon my French, are fucking breaking the law by manipulating it and creating any kind of scheme within these patents and trademarks. They're jumping jurisdictions. They're forging documents. They're fabricating accounts. They're committing every possible unlawful, illegal, immoral act you could possibly even think of. Yet they're coming out in the public as a licensed legal practitioner and saying that you're a deadbeat liar and cheat, you defaulted. Fuck you. That's treason. My opinion. That's treason. That's clear cut treason right there. So continuing on, anyhow, the occurrence of any of the following shall be a default under deed of trust: failure to pay any indebtedness secured hereby when due, failure to perform any agreement of trustor. So the agreements that we talked about that we don't know about, when due, trustor commences a voluntary case under the Federal Bankruptcy Code as now or hereafter in effect, or any successor thereto. An involuntary case under such bankruptcy code is commenced against trustor and is not controverted, or if controverted, is not dismissed within 60 days after the commencement of such case. A receiver, trustee, custodian, or similar official is appointed for or takes charge of said real property, said collateral, or all or substantially all of the property of the trustor. Trustor commences or any other proceeding under any reorganization, arrangement, adjustment of debt, relief, or debtor's dissolution, insolvency, liquidation, or similar law of any jurisdiction now or hereafter in effect relating to trustor. Any such proceeding is commenced against trustor and is not controverted, or if controverted, is not dismissed within 60 days after the commencement. Trustor is adjudicated insolvent or bankrupt. Any order or relief or other order approved in any such case or proceeding is entered. Trustor makes a general assignment for the benefit of creditors. The occurrence of any breach, default, or event of default by trustor under any instrument or any agreement whatsoever, evidencing or securing any indebtedness or obligation owned by the trustor to General Electric Corporation, Capital Corporation, individually, I'll get back to that in a minute, individually or as agent for any other lender or any substitute therefore, replacement therefore, or successor interest thereto, collectively the credit agreements, and such breach, default, or event of default is not cured by trustor within 30 days after such occurrence, or there has been a breach or a default under any of said promissory notes or any other provision of the deed of trust. Upon the occurrence of a default under this deed of trust, and as long as any such default exists, beneficiaries shall have the right to declare all indebtedness secured hereby to be immediately due and payable, and such indebtedness shall thereupon become immediately due and payable without any presentment demand, protest, or notice of any kind, all of which are expressly waived by the trustor. So what they're doing there is when they foreclose upon you, you know, the house, yes, the house, they're going after the house, but what they're really going after is the underlying instruments that we're talking about that are attached to it. All these different slices, all these different deeds, all the annuities that are attached, all the insurances that are attached, all these things that are attached that they cannot access and they cannot grab, so to speak, unless a default is stimulated that kind of pulls them out of the collective membership and puts them into like a receivership. So what these foreclosures are really all about is it's about getting you to abandon your property by eviction that you think that you believe is an eviction of a house and of a foreclosure and default on a mortgage on a real property. It's all bullshit. That's all to get you to think that you're getting thrown out of your house, think that you're a deadbeat liar and cheat. They got to get you out of your house, evicted from your house, so that they can go to Patents and Trademarks as your authorized representative and say that you're a deadbeat, that you're incompetent, and they're here to what? To collect the annuities, insurances, and everything that they've built up on your estate. It's absolutely disgusting. This is what they're doing.
And they
Upon
also
the
do
occurrence
it.
of a default.
Yeah, the other thing too is they do it for any bill that they think you defaulted on or that goes to collection. It could be your AT&T bill that they have monster amounts of money that they've built onto it. And as soon as like you forget to pay the payment that month, even if you get back on track, they can pull it all. If that payment isn't made on that day, they can actually drain out what they've already accrued in those accounts.
That's right. That's right. And see, this is where the OCC should be held responsible, the Office of the Comptroller of Currency, because when they enacted deregulation and preemption and they stripped that fiduciary duty away, they might as well drop us off naked in the desert, because that's what they did. I mean, we have no protection. First of all, we have no knowledge of these things, right? But second to that, we have no protection. We have no remedy, no relief, and the people that are committing that against us are acting with impunity. Yes.
Liz has her hand up. Sorry, I just noticed it.
Oh, we don't want to hear from Liz. All right. Hi, Liz.
Hold on, her microphone's locked up.
Okay.
She's got to turn her microphone
on. Hey, Liz, how
on.
you doing?
No, there she is.
It wasn't very nice.
Oh, come on. You know, I'm just joking.
I know. I just wanted to follow up on something you said about getting evicted. And this is when they can claim that you abandoned your property. In the case, you know, those, we've done certain filings that have secured our name. At what point though, now, if they were to come to my house and say, you know, the sheriff comes, we're evicting you, and I say, I'm not moving, you're going to have to carry me out of the house. Is that still considered an eviction, or can that be construed to be armed robbery?
Well, at that point in time, they have no rights because you stripped all their rights. You know, when you make these fines and patents and trademarks, what have you done? All the rights that you've presumably granted them to enter your property, right? You've stripped it from them. They have no rights anymore on any. They have no rights whatsoever because you've stripped all their rights. You basically rewrote the contract with this, so they don't have any right to come onto your property. So it's going to be interesting. It's going to be interesting to see how this does proceed from here, because I think that at this point in time, you know, the documents that you record. Patents and trademarks, and this is what Bridget and I were talking about earlier. These are legal documents now. These are documents that have been looked over by the Commissioner of Patents and Trademarks and have been approved for registration and recording as not fraudulent, and thereby it's a legal document. You've rewritten the contract, and I think that's a very powerful thing.
So, but my question is, if they proceed anyway, and they actually kick us out.
Well, another thing too is that there's a great possibility, just having been in a lot of this for a long time, so I'm not trying to start fear, but a really good friend of mine is an ex-common law court judge, and we talk about a lot of this stuff and how you know, a lot of these people just do what they want because a lot of the law enforcement now works for attorneys.
No,
right?
you know,
Because
but I guess what I wanted clarification on is in terms of the fact that only a few of us have actually done those recordings. If they proceed anyway.
So I don't know anybody who's used any kind of legal paperwork that the sheriff didn't ultimately toss them off their land. We had a huge movement here in Reno for about
I have a
10 years.
specific question
But
about,
wait, I know what you're getting at. Here's the deal, Liz, and we've
Okay.
talked about this. The deal is this. The deal is this. It is within patent's own rules and regulations, and within their agreements themselves. That once we make our claim, so to speak, if that's what you want to call it, or take that name, take possession of the name, they have the obligation to cooperate with us, to return all the properties, to produce all the evidence and documents, to reconvey everything back to us. You know, nothing's going to prevent the sheriff from coming on and throwing you off your property. Are they going to get away with it? No, they're not going to get away with it, because now with these documents here, at present you have no standing whatsoever. You're just a lump of living matter. That's it. But now, when you make these recordings of patents and trademarks, what have you done? You've given yourself a physical existence as an individual personality, okay, that has vanquished all these intermediaries. And in effect, you've taken away stripped them of all their immunities. So, and you've also given yourself legal standing. Now we have the right to sue the hell out of these guys, and sue the hell out of judges, to sue the hell out of anybody who's trespassed upon us. And this is not my words. These are the words within their own agreements, so that we flip back against them. So the answer to your question is, it's going to be interesting to see. There's nothing what stops them throwing off your property is that they have no right to throw you off your property. Now, are they going to abide by it? We're going to find that out, I guess. But they're going to lose. They will lose.
is there anything that we can do in terms of providing them with, I don't know if these filing, because some of them are multiple pages, many multiple pages long.
They're 4 pages. They're 4 pages long. It clearly describes what you wrote the contract. They have no rights. That, to me, that is as good as to get the hell off my property.
Right.
It's a legal and binding agreement.
One document that I filed into the USPTO is 41 pages long.
Yeah, but we've also, mine is too. I mean, both me and Liz submitted about the same time, and similar documents. My document was intended to blow the lid off of this thing. There's a lot of things in there that don't need to be in there, but it exposes everything. And that's on public recording. That is on public record. Now, since then, all we really need to do is get down to the basics of, hey, you know, you stole my prize winning pig, you stole my identity, you presumed that I agreed to something, which is indisputably rebutted on the fact that it's indisputably impossible for me or anyone to voluntarily agree to something that I have no knowledge of. So therefore, all these presumptions are overturned. It is a duty, therefore, of Commissioner of Patents and Trademarks under their own rules and regulations to correct for affected errors, and that's what they need to do. They need to perform their duties at this point in time. Now, as far as whether sheriffs or these people are going to abide by these things, I don't know. That's going to be a good question. Are they going to get away with it if they don't abide by them? I don't think they're going to get away with it. No, I don't think they're going to get away with it at all. I think we got them by the balls, and they would be foolish to attempt to do so, to not abide by these contracts and agreements. Because now you have all the rights. You've secured all the rights. You've secured everything here that you didn't have prior to that. Who's the only competent jurisdiction in the end run? Anybody?
Me. Us.
Who is?
We are.
Yes. And that's what's important about all this stuff. You got to be, you can't just do a couple of forms and just expect everything go back to hunky dory. It doesn't work that way. You got to be able to stand on these things. And Liz, as well as other people on this call that know me and have talked with me and have gotten into this themselves, realize that there's great power in uncovering these things, because you realize all of a sudden that, wait a minute, there's no law here. It's all ambiguous. The whole system's bullshit. That's power. When you have that kind of knowledge, that's power that you can utilize. And there's nothing that could prevent us from exercising these powers at this point in time. Because why? Because the whole damn system is in contempt, is acting in treason. And at the end of the day, this is one nation under God. They've messed with the initial separation of my body from soul, which was not their creation, but was God's creation, and under natural law. And all we're doing is we're claiming our rights to these things. We're showing that we have the competent knowledge and understanding of these things, and they have to abide by these things by their own agreements.
Okay. Thank you.
Well, do you see any other Liz, we don't know the answer to this question. These are new things. Nobody does know about these things. So it is going to be interesting to see how these people proceed. Now, it should never come down to the point where the sheriff should be knocking at your door. Why? Because when you do these assignments, you're turning. Remember, you're flipping the tail here. They become the debtors now, right? And it's incumbent upon them to do all the returns. Who are them? They are the banks. They are the attorneys. They are the servicers. So at that point in time, it should never even get to the sheriff at that point in time, because the duties to reconvey everything back is on the servicers, on Ocwen, on Bank of America, on IRA, on these attorneys, HSBC, so they have duties to perform. So it should never even get to that point of the sheriff.
Well, we will see soon enough.
Yes, we will. Yes, we will. This gets fun now. This does get fun, because what we're dealing with here is we're dealing with this is a Manhattan Project. You have certain people that know about these things. Probably what we're talking about here today, I would say probably not even 1% of the population knows about these things in its entirety. This is a need to know basis. You've got at the closing room table, you had closing agents that were passing misrepresentations of the principal innocently to you by saying, "Oh, MERS is just a utility function of Fannie and Freddie." Well, that's a lie, okay? But it's an innocent misrepresentation that is being that they're using government employees or closing agents to convey to us, who themselves are deceived. You know that yourself, Liz, from being in the industry, when you were talking about the accounting records and how you questioned it, but you thought, well, they know what they're doing, right? Well, did they know what they were doing? None of us who saw these things or ever saw these red flags ever mentioned anything about, because we thought there was honesty and integrity in the system. Well, obviously there's not, right?
Yeah, we had no idea.
No, we didn't. But going back to this here,
I'm talking about us industry people.
Huh?
I'm talking about us industry people, because I was a loan supervisor and a registered principal and all of those other things, and they never. We were scratching our heads wondering, how in the world are they getting away with violating all of these, these liar loans? And we
They created an entitlement system for themselves, and that entitlement system is they understand the power of that all capitalized name as a non-human factor of production. We look at it from a Social Security standpoint, and we have Social Security and pension and all these things. But what we fail to recognize is the fact that when they say we're a debtor slave, or they pull bonds on what our expected earnings are going to be over our life, we fail to understand what that all capitalized name actually means, and it hasn't helped us to have people out there saying that, oh, it's a fiction, it's not ours, it's theirs. That's as well intentioned as that was. It's misinformation, it's wrong information, because it's not true. That all capitalized name is not a fiction, number one. Number two, it is ours because it would not exist had I not given my first breath that created that. So, I mean, and of course, and as far as the corporations are concerned, why? Let's not spit on the corporation. We're the owners of the corporation. What we need to do is we need to seize our ownership of the corporation and not piss on the corporation. We can condemn it all we want to, and we're right to do so. But we have the power to change the corporation, because we are the actual share owners of these things. But until we start realizing these things, we're just going to keep on going in this cycle that we're in now. And I fear that we're going to be driven all over a cliff here real soon, the way things are going. This has to stop. What's going on in patents and trademarks, nobody has put an eye on, because we've been directed elsewhere. So for 20 years, these guys have had the run of the mill. And what have they done? What has happened here? Has anybody really progressed? Has anybody? No, the 1% has progressed. Why are the 1% progressing? Because they have the secrets of patents and trademarks. They're holding on to the
yeah,
trade
and the
secret.
1% are attorneys now, right? They're not the other people. They're the ones in these yachts. I tell people, please go watch that on Netflix, Billionaire Yachts, and you will be blown away, because everyone they introduce that owns a yacht, oh, this is an attorney from France. Oh, this is a guy's attorney from the U.S. This person's like an attorney. And they own the greatest wealth in the world, and it's in boats on the water.
Yeah, and really, I mean, if we really wanted to make a stand and really wanted to make a change here, we talk about conspiracy theories all the time. I see, especially with what's going on now in the world with COVID and with the murders of George Floyd and other African Americans and all the protests and everything. There's a lot of stuff being said that really just is unnecessary. It's not true and it's very divisive. But instead of paying attention to those things, let's pay attention to ourselves and look inside ourselves and say, wait a second, yes, things suck, things are terrible, okay, but we can do something about these things. What's going on now I think we're in a very good position right now, and poised to make a change, because COVID, no matter what you believe about it or what you think about, has at least woken up the people. The murders of George Floyd and the racism has woken up the people, and people, because it's not spoken about racism itself, but how the whole system is corrupt. And so everybody sees how corrupt the system is. Everybody's sick and tired of this system. So we're poised right now to make a big change for ourselves. And what we're doing here in patents and trademarks is incontrovertible. It's undefensible. They can't defend it from their end. There's nothing for them to defend. I mean, this is the bottom basement here. And these are things that we can execute that are, if you want to call them administrative, I guess you could say they're administrative, but not in an administrative sense that people are doing things now, but it's not court related or anything. It's an instruction. It's an instruction to the Commissioner of Patents and Trademarks to make a correction. And what is that correction? That correction is for all the agreements where a bank or whoever came in and said and acknowledged the fact that, yes, that person that's attached to these trademarks, these patents, that person, that grantor, is the owner of all rights, title, and interest, sole beneficiary, but for the fact that they pledged all rights, title, and interest to a nominated agent, which is me, the attorney, or whomever, and we instruct the Commissioner of Patents and Trademarks to make these necessary recordings to reflect this. So all we're doing is coming in and saying, wait a second here, no, this never happened. This presumption is indisputably rebuttable for what I said before, because you can't volunteer for something you don't have any knowledge of. And what we're asking you to do, Commissioner of Patents and Trademarks, for your open duty, is to make the correction to record, to correct the affected errors. It really is that simple. It comes down to that simple, simple paragraph of what I said. All the things that we're doing by fight. I mean, what makes me mad about this most is that all the time that you've wasted, all the time I've wasted, we've wasted so much time fighting the courts, fighting the court system, fighting these foreclosures that, don't even exist. We've wasted our time. We've wasted our life. And this was intentionally made to do that, intentionally engineered for us to do that. To me, that angers me. I mean, because life is short, right? We go a certain number of years and that's it. And they have set us up into a situation where we are intentionally wasting our time. And we've been set up in a situation where our existence, literally our existence, the reason why we exist is to serve to their pleasures and profits. And you can see that within this document I read you. You can see this, how we're being used and manipulated, and we're just their play toys. What's going to beat this is not affidavits and case law and constitutional law and all these things other people are doing, or secured party credit or redemption or anything of that nature. What's going to do it is by stepping forward and pulling out of ourselves and better understanding of ourselves and the power that we have, and say, wait a second, I'm taking that all capitalized name is mine. I'm taking all rights to that by the very fact that I'm coming forward in patents and trademarks. And you did this today, Bridget. You signed your name between those hash marks that said, I'm the living individual. I'm sorry, I'm the natural person that belongs to that all capitalized name, and I'm taking claim to that.
This is the thing that I really like about the whole patents, copyright, and trademark stuff, is that it's out in the open. It's public. They have publicly telling you what they're doing. Where, like with common law and other stuff that I was dealing with, and something would happen and I have to derive some paperwork, and it was kind of like, I'm going to slap it and stick it on the wall and see if it sticks, because I'm not really sure what I'm fighting against. I don't really know what kind of paperwork is needed. Where copy, patents, and trademarks, it's like, you go in, you look at the companies who are trading you in any way, shape, or form, manufacturing, and you go in and you look and you find the names. Oh, wow, it's public. And then you go and you look at the name and the trademark, and you keep looking at that name, and then you look at the other companies that company has derived, and then you go, wow, oh, and here's a serial number. Okay, so then when I file,
well, and here's
it's there. I mean, it's like, so I don't have to go like make stuff up. I can just go look at the facts and I can utilize the information instead of, like I said, trying to do common
Now
law
the question,
paperwork.
now the question that people bring up is like, prove it to me. How do I know? Where's my name in patents and trademarks? Where can I find it? Here's the thing that you got to understand. You're not going to find your name trademarked. You're not going to find your name patented per se, because we're not talking about the word. What we're talking about here is they're using our all capitalized name used in connection to the goods, products, and services and patents of others. So they're using us in connection. That's a very important phrase there.
But
So they're
also
attaching us to a.
yeah, but not
But hold on,
only
let me
using,
finish.
not
Let
only
me-
using your name, they're
me
using
finish.
numbers, right, that they've derived too.
Right, yeah, right. Well, yes, that's right. But let me switch my point to that. These names in these customer lists, what are they doing with it? They're monetizing them, right? They're putting them into investment schemes for annuities or for whatever. And you're right. Another thing that they're doing that's more divisive is they're further separating us from our identity because they've created digital signatures and business identifiers and UPCs and all these codes and stuff by numbers and code and everything that further separates us from these things, from our investments, our properties, and our rights. And so what we are in the end run is we are been disabled by all these systems, and we are disadvantaged because, hey, they've got a 20-year head start on all these things. They have the technologies, they have the operations in place. So we're disadvantaged, disabled, and you know what? I'm going to put myself together, merge everything together, and self-eject myself out of this damn system. I don't want to be a part of it anymore, and I have a right to do so. And it says so within these agreements. You have a right to come forward and take everything back, and they have to give it back to you. It's to me, I've studied this for years, so I mean, obviously I've an advantage here, but for me, when I look at this thing in its very simplistic form, what we have to do here is not complicated. The most complicated part of it is learning something new, okay? But once you learn the concepts behind this thing, it becomes pretty damn clear that, holy shit, this is the simple way to cure things. This is a simple remedy. And holy shit, these guys are criminal as hell. They got to be stopped. And the only way we're going to stop them is if we come forward as individuals and say, nope, no more. Put a face on these patents and trademarks where there's no face right now.
Yeah, and put our face on it.
That's right. That's right. That's right. We all these pharmaceuticals, all these chemtrails, all this stuff. We got to realize we are the stock owners of all these things. We're the ones that are funding these things. We're the ones that are funding to these planes, building these planes to spread chemicals over us, to research about pharmaceuticals and do all these things. Where do you think they're getting the value from? Where do you think they get that money from to do these things? From us, by attaching us to these customer lists. And what are they doing? Monetizing them, right?
And it's even more blatant than that, because they started, I think in 2013, I think it was like the UN started issuing different kinds of bonds for different kinds of pandemics. And in June right now is when the big COVID-19 bonds mature. And so they needed to have as many people to test positive as possible, because countries, basically these bonds were created for countries, based on virus and pandemics. So, it also, we have to really kind of think about that. Like right now, we'll probably see a big insurgent in fake money in the fake money system, because they're going to release the pandemic COVID bonds based on each country's amount of people that had COVID and that died from COVID. And so, they're just making money off of everything. And then they corrupt everyone and everything by, including them into these, systems. So, in order for them to have made money, they had to give, number one, people COVID. Number two, people had to test with COVID. And then number three, people had to die from COVID. And your numbers needed to be really high to get, all the interest payment from the bond for your country. So, I mean, this is
and here's the thing.
Yeah. Go ahead.
Sorry. Well, and here's the thing about patents and trademarks. There's a lot of conspiracy theories out there about the British Commonwealth and the Queen and the Vatican and everything. But you want to quit spinning the conspiracy theories. Get your head into patents and trademarks, because this is where the proof is at. The proof that we are pipelined over to England is in patents and trademarks. it's unequivocally proven that this system has been corrupted. Our court system has been corrupted by foreign bank debentures. They're recorded within patents and trademarks. It is a fact that the first American title has converted us to lease agreements and convertible digital business objects, tradable business objects, and that we are pipelined over to Allied Irish Bank from First American Title. It is a fact that we are funneled and laundered through the state of Texas to be laundered up to Canada, to be laundered through the so-called elective dictatorship under the Queen of Parliament. All these things could be, all the conspiracy theories that people are talking about, most of them at least, can be proven within patents and trademarks. So why are we doing it? Because we don't know about these things, the patents are very boring. They're very dry and very boring, but it's not the patent itself. It's everything that surrounds this thing. And here's the thing. The Patent and Trademarks Office, all they do to record these things is they have a certain criteria to follow to make sure that all the requirements are met in order to patent for a patent or for a trademark. They're not delving into, there's not a patent examiner that's just scrutinizing every one of these patents. They're not doing it because they're not qualified. Number one, I mean, is this person a qualified banker or what? No, they're not. All they're doing is making sure that they meet the requirements for recording, and they get away with it. And they keep getting away with it, and they've gotten away with it for 20 years, and it's gotten so bad because why? Nobody is questioning these patents. And because nobody questions a patent, nobody files a claim against a patent or files an assignment on a patent, that the Patent and Trademark Office won't even look at it. So what we're doing here is we're saying, hey, wait a second here, these patents need to be looked at. Somebody needs to look at these things. And by the very fact that we're making a claim on these things, initiates a couple of actions. And these are the actions it initiates. It is under their own rules that when these claims are made, in cooperation with U.S. Customs, the accounts are also, everything is supposed to be audited. Treasury is supposed to audit everything. Now, these aren't the audits that people are getting now. These are the audits that are going to go deep. These are the audits that will go right into patents and trademarks, which is what needs to get audited. Because once they get into these things, once government gets into these things, I think government themselves are going to be pissed off because these things are so blatant. It's like a Wild West orgy that nobody's looking at. Nobody's controlling. The attorneys have taken over this country, have taken over this world, and I'm excited because this is a really clear and definitive way that they can't defend, and it clearly shows what's going on here.
And with that, we can end it. And because it's 5:41.
Yeah, I think so.
Okay. And
Okay.
Thanks for everybody coming. And I don't have any links for anybody this week. So because Ken wanted to read off that document so we could really see how, I mean, that's a trademark that he read from the Vineyard people, so that's a trademark. That's not even like the patent. But it's
these
like,
are the hidden agreements that we don't know about.
Exactly. All right, everybody. Thanks for showing up. Oh, go ahead. Do you have any last words?
Okay, that's fine. Yeah, I do have the last word to say. I will post up this link so everybody can see this agreement, read this agreement. The purpose of reading this agreement was hopefully it kind of opened your eyes to the fact that, to shatter any kind of belief that you might have had that these things are actually mortgage loans and negotiable instruments, and open your eyes to see, wait a second, there's a lot more going on here than I thought. And I never agreed to that. I never agreed to this. And that's what I want you to see. I want you to see that I never agreed to these things. But these are the contracts that are pertinent to us. And all these agreements, no matter what they are, originate in patents and trademarks. This is what our focus needs to be, guys. That's all I got to say. Thank you.
All right. Thanks, everybody, for coming and showing up. And we'll see you next week. Same time, same back channel. Bye.